If you've ever looked for legal writing advice and how to improve your legal writing, one of the places you're bound to have looked is Google. I know I did many years ago when I started to discover exactly what is good legal writing. So in today's video, I'm going to go through one of the top ranking articles that explains how you improve your legal writing and give you my views on it, whether I agree with it or if I disagree with it. So let's get started. The article we're going to have a look at is this one here, 11 Persuasive Legal Writing Tips for Lawyers, which you can see on the first link above. I'm going to be assessing the advice given in that article against the most important piece of legal writing doctrine that we have today, at least in my opinion, which is chapter 2 of the Plain Language ISO, which is specifically on legal communication, which you can see right here. The clip that I've taken from the website is freely accessible. There is, of course, a paywall to get the whole ISO, but there's enough information there on what's freely available to give us an idea of what the ISO wants from us. And of course, the article 11 Persuasive Legal Writing Tips for Lawyers is freely available by clicking on the link in the video description below. So please go check that out as well. So that's the plan for today. Is this going to be good advice? Is this going to be bad advice? Or is this advice going to have some pros and cons? Let's get started. There are 11 tips to go through, 10 of which are specifically important as regards writing, as you would expect. It's telling you how to improve your writing. This is tip number 1, understand your purpose. And what I'm going to do in this video is I'm going to read through them at super fast speed and then either wait until the end to give you my opinions or break it down as I go through. Anyway, that's not very important. What's important is what I think of these. So let's go. Understand your purpose. What is first and arguably the most important legal writing tip? Understand the purpose of your writing. Possibly, it depends how we frame it. Let's see how this advice is framed. Ask yourself, Ask yourself, why are you writing this? What are you hoping to accomplish? What is the outcome you wish to achieve? Writing a contract may serve to inform, while court documentation may serve to persuade, and client intake documentation may serve to evaluate. The structure, tone, and voice of your document will change depending on the purpose of your legal writing. Understanding that purpose will help you to write better. Right. When I said it depends on how it's framed, we have to bear in mind what chapter 2 of the ISO says. The ISO in general sets out the principles of what is good communication, what communicators should aim to do. And the most important message that we can take away from the ISO is that we have to put the reader first. In the communication relationship, you have the communicator, either the orator or the writer, and you have the person receiving that information, whether they're listening or whether they're reading. In that relationship, it's the person receiving the information, either whether they're listening or if they're reading, which is the most important part, okay? If they don't understand your communication, in my opinion, is rather worthless, because you can communicate all you want. You may as well be talking a different language if they don't understand what it is that you're actually saying. So the reader, the listener, has to be the point of the thing that you think about when you are writing. But if we have a look at this advice, it's entirely writer focused. Ask yourself as a writer, why are you writing this as a writer? What are you hoping to accomplish as a writer? What is the outcome you wish to achieve as a writer? What this should be saying is, what does the reader hope to get from my writing? What is the reader hoping to accomplish when they receive my writing? What is the outcome the reader wants to achieve? And how will my writing help them achieve that result? That is the correct framing. So that's why I agree in principle with the advice, but it's aimed at the wrong person. It's aimed at the writer. It should be aimed at the reader. And as legal communicators, we have to bear that in mind. We have to be aware of that. If we have a look at these examples, a contract may serve to inform the reader, not the writer, while court documentation may serve to persuade the reader, not the writer, etc., etc. So you're trying to persuade someone else. You're trying to inform someone else. That someone else, the reader, is more important than the writer, so therefore the writer should always put the reader first. Tip number 2, understand your audience. Knowing who you're writing for will help shape the structure and tone of your piece. A judge, another attorney, or client will have different experiences and expectations that inform how they read your work. When it comes to your audience, keep the following in mind: their role and relationship to you, age, income, economic status, level of education, values, and how much they already know about what you're writing about. This will help you determine the tone, style, and level of detail to include in your writing. Once again, some good things here, but what this might allow you to think is that your communication comes on a scale. That is to say, if you're writing to someone who doesn't have that much knowledge of law, then you would write in this way that you can communicate to them, or you should be anyhow. So you would structure your writing in such a way, you would choose vocabulary in such a way that they would understand. But it may lead you to believe that on the other end of the scale, if you're writing to a judge, you can get away with legalese or horrible structures or traditional legal writing or something like this. But we know that not to be true. We know that legal professionals also want communication to be communicated in an easy to understand way. Okay, the empirical evidence is clear. We had a look at that in previous videos. I'll link to those videos down below. Everyone wants plain, clear communication. It's not that you can even start to think that I'm a lawyer, I'm going to write to another lawyer, we've got to cooperate in some way, so I'm going to make my writing as hard as possibly can so we can communicate better. It doesn't work like that, okay? So there is no scale. All communication should be using simple, professional, easy to understand structures, using difficult vocabulary, because you can't change the vocabulary sometimes. You've got to use legal English vocabulary, but at least you can communicate it in easy to understand structures. So understand your audience, yes, but you should always have plain language communication principles in mind, no matter who you are talking to. Tip number 4. Tip number 3 was about doing research. It wasn't directly relevant to writing, so I've skipped over that. Create an outline. One of the most helpful writing tips to improve your legal writing skills is to organize your research into an outline. Start with an outline to help you keep your writing organized and focused. A good outline starts by detailing the topic and then putting the most important information at the top, then flush out the main points with the supporting details while making sure the transitions between the points make sense. Legal writing becomes much easier and less intimidating once you have an outline to help organize your ideas and guide your writing process. Yes, I am a huge fan of planning. Okay, planning is really, really important. And once you get good at planning, then effectively that plan becomes your first draft. You can then analyze your plan, and as you're going through the writing process, you're actually thinking, okay, how can I improve and develop and build upon those ideas? So yes, an outline, a plan is fantastic. But here I'm going to roll on to the next tip, which is put words on a page. So it develops the point. It says, even with a detailed outline that you've just done, getting started can be difficult. Writer's block is a real thing that even the most seasoned legal writers suffer from, but don't worry about getting it perfect on the right try. That's what editing and proofing are for. Here, some alarm bells are beginning to ring. The planning process is not just about setting out what you want to say. It's more detailed than that. It's actually choosing the language that you wish to communicate. So in the English language, the most important part of the English language of a sentence is the verb. If you've got a strong verb, then you know who's doing that verb and you know who's being affected by that verb. And what we have there is the active voice, which is generally how normal communication happens. So if you plan and you know your verbs, you then are able to then get to know your messages. You then get to know who's doing things, who's being affected by things. And then you make the decision of which messages would be better then for the passive voice, because the passive gives me a little bit more nuance, or I have to use the passive because I don't know who the subject is. You start to analyze your writing in that way. You don't automatically tend to prefer the passive voice, which is what lawyers or legal writers tend to do. You get that process done in the planning. Okay, that's why the planning should be that specific. It's not just a general outline. It really does go into a fair bit of detail, which is why then I say when you start writing, that then in effect becomes your second draft. That is a process that takes time. It's not something that you're going to get right straight away. On your first draft, getting back to the information, focus on capturing the right information. Make sure that the information is complete and sufficient and the content flows nicely from one section to the next. Once again, that transition, that flow, should be part of the planning process. You should know what discourse markers, which transitions you should be using in order to move from one point on to the next. That persuasion should be part of the planning process. Give yourself as many drafts as you need before your deadline. Also, give your writing some room to breathe by taking a break and coming back to it with fresh eyes. Once again, here the information might not be realistic. You might not have the time. Remember, you are writing under pressure. You don't have the possibility to write 10 drafts. You might only have the possibility to write 1 draft or 2 drafts. Okay, because that's the time pressure. You need to get things written, you need to get them passed up the chain, you need other people to have a look at your writing. So this advice might not be necessarily realistic. However, the advice about putting yourself in a position to objectively review your own writing by taking a break for 5 minutes is very, very good advice. Now, I don't like this last bit. Always remember that you can clean up your writing in the editing stage. You don't have to get the formatting perfect on your first try. This idea of kicking this can down the road, the proofreading, the editing can wait, this may be problematic, okay? You need to develop the skill set of being better with your proofing and editing, and the more you practice that, the better your first and second drafts will be, because you're going to catch those errors as you are using them. So, for example, I've been involved in plain language, improving legal writing for a very, very long time, best part of 2 decades. When I'm writing, I still use legal prepositional phrases such as in order to, whereas I've been telling people not to say in order to for the best part of 20 years. We can just say to, okay? So in order to do this, okay? I do that instinctively, but at least when I do it, I catch myself doing it and then I can correct it straight away. When you develop your proofing and editing skills, you're able to do that. It's not just an afterthought that you hope that you might identify later on in the game. Also, if you're asking someone else to have a look at your writing and you catch all those issues at the beginning, then it makes that process of reviewing your writing a lot better if you're sending your work to a proofreader. But if you're sending your work to senior lawyer or to partner, then it makes your writing that much better that they don't have to identify this. You've already done it. Okay, so tip number 5, let's say 50-50. Be aware of context structure. The best way to structure any piece is by writing from the top down. Start by showing the reader what you're writing about and why, then provide the arguments to support your case. Pick the most persuasive arguments to focus your writing on, then filter additional supporting arguments thereafter. Use headings to break up sections and transition from one argument to the next, and start new sections with summary sentences. Where appropriate, it may also be helpful to use lists and bullets to make your writing scannable for the reader. Okay, so there's 2 parts to this advice. One part I'm not going to really discuss in any great detail, and that's how you structure your writing. Different legal documents require different forms. Generally speaking, readers appreciate it when you get straight into the information, the executive summary, as it were, as quickly as possible. You don't beat around the bush, you get straight to the information. Generally, readers appreciate that. And that's all I will say about that. When you go through law school, you learn about different structures, how you write different things. That's a different discussion. What is important, though, is the second part of this, or the second paragraph. Choosing your arguments and how you emphasize those arguments. Emphasis is a huge part of plain language drafting and legal writing, of course. Using headings, using transitions, using tabulation, where it says lists and bullets. Yes. Big part of plain language is introducing white space into the text to break up a paragraph and communicate that information in a way which is easy to see, easy to interpret, and then easy to find again in the future. Okay, massive plain language technique. If you're not using tabulation, if you're not using white space, headers, subheaders, and so on, start using them. As a matter of fact, I've done plenty of videos on this. If you want to check out my course, which is available online on YouTube for free, 50-lesson course, then please click on the playlist in my channel. The link is in the video description. Tip number 7, tips to help you write better. And tip number 7, be clear. quite an umbrella term. We'll see what's going on. When writing any type of legal document, state your point directly and clearly within the first few sentences to help guide the reader along. Yes, as I was saying, get to the point, let the reader know what the issue is, what, if you do an executive summary, what the conclusions are at the beginning, if you do what do they call it now, the TLDR, those are useful as well. So communicate straight away what the writing is about. Assume the reader has very little time or patience, always a good approach. That they hate to read, always a good approach. And that they're only going to read the first 200 words. Because people generally are stressed, they're busy, they don't have time to work out what it is that you want when you write to them. So that's good advice. What you say in those 200 words will help them decide to continue reading. Yes, absolutely. This is why subject lines in emails are so important, because if the subject line is drafted badly, your email gets ignored. I've done an email course, which is again available on my YouTube channel free of charge. 10 lessons about how to create hopefully a successful email. Go check that out. But the subject line, it really will decide whether someone will read that email or not. Anyway, getting back to this, we've got legal writing tips to bear in mind. Active voice. Yes, if the advice is prefer the active voice, not use the active voice, don't use the passive voice. That is bad advice. Prefer the active voice is better advice. Avoid double negatives. Well, yes, clearly grammatical mistake. We can't have double negatives in English. The Oxford comma, yes, for the purpose of legal writing, the Oxford comma is critical, is absolutely critical. I'll explain why in a future video, but needless to say, there are court cases which come down to the fact that the Oxford comma was not there, and if it was there, it would have saved the companies, two companies in this case, an awful lot of money. Use adverbs and adjectives sparingly. Yes, experienced readers are not persuaded by adverbs and adjectives. You might think that they perform some kind of magical role in persuading the reader, but experienced readers will just simply skip over adjectives and adverbs. Okay, so use them sparingly. Consistent tenses, consistent tense to the point that it's logical that the communication that you're communicating stays in the tense or the change in tenses makes sense. But tenses are a tool to help you communicate different things. You're going to talk about the past, you're going to talk about the present, you're going to talk about the future. Just saying communicate in the present voice is, in my opinion, a bit of silly advice. Avoid split infinitives. No. The doctrine is clear on this. This is old-fashioned English advice that you should stop. You should split infinitives, or, for example, you shouldn't put prepositions at the end of the sentence. Debunked, argued against successfully, in my opinion, many, many times over. Avoid gender-specific terminology. When in doubt, they is universal. Now, how do I frame this? I would say I'm a big fan of using them and their, but this is nothing to do with, let's say, modern thinking about using them and their. Them and their is used, or are used, to avoid the mess that's created by saying he, she, his, hers, etc., non-stop throughout the document, or getting it wrong when you're talking about the woman, but then you're using the wrong pronoun, or you're talking about a man and you use the wrong pronoun. Okay, just using them there makes life easier, and it's easier for the reader to understand what's going on. Okay, and with clever drafting, then you're able to communicate that, even if you're talking about someone in the singular, that it makes sense when you're using them and their. We've been doing this in legal writing for decades. 40 or 50 years ago, there was doctrine saying prefer them and their over the singular pronouns. So that's the way I would frame it. No slang and hyperbole. Of course, there's legal writing, there's a level. We shouldn't be using slang or hyperbole unless, or hyperbole, I don't know, how do you pronounce it? Unless you are quoting someone or for effect, or if the audience that you're writing to is appropriate for that kind of thing. So, for example, there may be a case if you're doing some writing for the general public, and then a usage of slang or hyperbole or hyperbole would be acceptable. But I would caution your use of this if you're writing to a judge, for example. Be accurate and specific. Goes without saying. You are lawyers. You should ensure there is accuracy and specificity in your writing, and that shouldn't provide any room for ambiguity, which is why we shouldn't be using certain words such as shall and or provided that in your writing. I've done videos about that as well. Tip number 8, jargon when only use jargon only when appropriate. Using jargon, including legal terms, is only appropriate in some contexts. For example, using too much legalese with a client who is not well versed in specific legal matters may end up confusing them and muddling the conversation with unnecessary questions. While in court documents are completely appropriate and sometimes even necessary to use the correct jargon and terminology, since another attorney, judge, or magistrate will be your reader. When appropriate, you strive to use plain language in your legal writing while showing that you understand the jargon and can present it in easy to understand ways for the reader. Okay, so what we've got here is, in effect, we've got a pot and we're throwing in legalese, we're throwing in legal terminology, we're throwing in plain language, and we're mixing it around a little bit. And we're saying, that's what this advice is. Let's break this down a little bit. So legalese, I would classify this as the horrible, like, legalese adverbs, here, in, thereafter, etc. The horrible legal words that we shouldn't be using in communication. We've got legal English vocabulary, which we have to use because if we're talking about mergers and acquisitions, if we're talking about intellectual property, then we have to talk about intellectual property and we have to talk about mergers and acquisitions. It's senseless to describe these in different ways. So that's legal vocabulary. And then we've got plain language communication structures, which unit tip 7 touches upon. We're preferring the active voice, using the passive voice where necessary, avoiding overcomplicated structures such as inversions and complicated conditional exceptions and things like this. In effect, we need to be using professional language and easy to communicate structures. That's what we have to do. We use jargon because we have to use jargon because it's difficult to explain one word in 50 words several times. Okay, that's how we should approach this. Once again, I don't like the idea that it suggests that if you're writing to legal professionals, you can use all of this language which no one really likes. Okay, that, in my opinion, is bad advice, and I talked about that in one of the tips earlier on. Tip number 9, edit and proofread. The legal process doesn't just stop when a piece is finished. One of the most common mistakes writers make is not budgeting for the editing phase. A thorough editing and review process takes time. It does. Send me as a proofreader a document which is 20 pages long. It's going to take me a few hours to go through it. Okay, it's not just hop, shoot, it's done. I need it back in 5 minutes. Well, there's not much I can do with a 20-page document in 5 minutes. I've got to go through it. I've got to analyze it. I've got to review it. I've got to understand it. I've got to make the changes. So the proofreading process takes time, okay? It's always helpful to have someone else edit and proofread your work. Yes, it is. But you should be able to take care of the basics yourself. Yes, you should. Master spelling and grammar basics. It goes without saying. Lawyers who present documents with spelling and grammatical errors will be seen as less credible and lacking attention to detail. Yes, if you're a lawyer and you're writing and you're making mistakes, or you've got inconsistencies throughout your writing, then it's going to reflect on you that maybe your thinking is muddled as well. I mean, that just goes without saying. Understandably, it can be difficult to catch spelling and grammatical errors immediately. Once you've read your document several times, you'll usually glaze over your own mistakes. So yes, if you're accustomed to writing in a certain way and you're not aware that you're making mistakes, then when you are aware, hopefully you're then able to identify those mistakes. That's how we improve our writing skills. We do a course, for example, my 50-lesson course, which is available on my playlist. You find out what writing errors are that no one has ever told you before. And then as you're going through the writing process, you then identify that in your writing and you go, aha, okay, that's a problem. I need to redraft that. So awareness is key. Other people looking at your documents may be able to identify this. Some other helpful legal writing tips for the editing process includes reading your writing aloud or reading it backward to help hone your focus and spot errors you otherwise miss. Yes, I know anecdotally, having talked to the proofreaders and copy editors that I've spoken to in the past, different proofreaders have different approaches to how they approach the text in order to perhaps see errors they wouldn't normally see. So if you're reading it in a normal way, so left to right, top to bottom, you might not see some errors. But if you read it, for example, backwards, paragraph by paragraph, where it's kind of then the structure is atypical, you're then much more likely to then, if it works for you, of course, it doesn't work for everyone. For the people it works for, you're much more likely then to see English language errors. You're much more likely to identify things that you wouldn't normally identify if you read things the right way. So proofreaders do lots of wonderful things in order to try and identify the errors. In general, if you've got no one to review your writing, as was said earlier on, go away for 10 minutes. If it's possible, come back to the document the next day. Really, you need time away from your document to then approach your document and then say, okay, I need to do this X, Y, Z. Remember the general rule. The first draft of anything is always rubbish. That's it. The first draft is always rubbish. The second draft is always going to be an improvement on the first. The third is going to be an improvement on the second, etc., etc. Tip number 10, use helpful tools and apps. No matter what medium or document you're writing, all good writers should always use a spell checker at a minimum. I would hope so. Advances in writing technology have also made legal writing much easier. For example, writing apps like Grammarly and Ginger can help you catch grammar, spelling, and other language mistakes. Couple of things to say here. First of all, confidentiality. If you're using an open third-party product and you're putting confidential information into that to spell check it, clearly don't do that. Okay, it's a terrible idea. The second thing is you've got to be aware of where the data is sent. So in the EU, I'm based here in Poland, you've got to be really careful that the information is kept within the EU. If it's sent outside of the EU to Britain, to America, wherever it might be, that might cause problems. Now, the issue with Grammarly and Ginger is that information is sent to American servers where it then the magical things happen, and then you get to see what the language errors are, what the editing, where that spell checking magic identifies errors. So you've got to be careful of where your data is sent. If you don't have an editor always available to help proofread your legal writing, I'll just turn my phone onto silent, which most usually don't. Text-to-speech apps such as Natural Reader can help your documents out loud. This will help spot errors and awkward passages. I don't know this app, couldn't tell you. I would imagine the same rules apply as I've just said. But I would say reading things aloud definitely helps you approach your text in a different way. Microsoft Word, for example, has got a read aloud function. I use it. It is quite useful. Clearly, there are some limitations to this. For example, if you've got a 90-page document, it's going to take some time to read through the whole thing. So just use that one if you can use that one, I guess. Let's say the Microsoft Word version. I wouldn't recommend a third-party app because I don't know what's happening to the information. While some of these services are free, many of them will have a paid version to unlock extra features. Consider investing in one of these paid versions if your job requires a lot of writing. No comment to make about that. Read tip number 11, and it's the last tip. Read other writers' work. The most common piece of advice writers give to those looking to improve their writing skills is to read. This rings true for any kind of writing. To improve your legal writing skills specifically, find a good legal and business writers and read their work. This could be legal letters and documents, but could also be books, blogs, and articles. By studying and understanding how others write and structure their pieces, you'll get a feel for the general format of a legal document. You can then incorporate your unique ideas and writing style. You could also ask colleagues for examples of their work or join communities and forums. Okay. I never liked this advice. Primarily because, well, for a number of different reasons, but the main reason is unless you can critically analyze the good writing that you are reading, why is it good? What is it trying to do? Why is it better than mine? Or unless you're able to critically analyze your own writing, why is it bad? How can it be improved, etc., etc., then simply reading other people's writing, I can't see the educational value for this. Particularly if you're writing, I know this doesn't say that, but I've heard it said before. For example, legal writers want to have better legal writing skills, so they're recommended to read Stephen King novels, for example. Excuse me. This is terrible advice. Clearly, novels and the language and the way that the English language is used in novels is not appropriate for a lot of legal writing. In fact, most legal writing. So, trying to then imitate Stephen King in your legal writing, I think is risky, not good advice. It says here, by studying and understanding how others write and structure their pieces. How can you understand if you don't know what it is that you're looking for? That's my main issue here. Ask others. I mean, you can always ask others for feedback. That could be useful. Once again, if you know that they know what they're doing, then that's more helpful than someone who will just look at your writing and say, "Oh, that's okay," or meh. So once again, I understand this is meant to be good advice, but it's only partly good advice. The other part has to be someone has to tell you what it is that you're looking for. Okay, that's my grumble about this. So there we go. 11 tips from this article, 11 persuasive legal tips, legal writing tips for lawyers. Some good things there, mostly good things in there, if I'm fair. One or two things that I'm not happy with, a few things that I would say need extra context or need extra kind of explanation. So I can forgive that to a certain extent because it's only an article. How long can an article be? Out of the other, compared to the other articles that I've read about how to improve, your legal writing, this would be definitely one of the better ones. But my leaving comment, or my final comment for you would be this. Here above my shoulder, I've got Chapter 2 of the Plain Language ISO, specifically for legal communications. This, as I said at the beginning, focuses your attention on the fact that you should be writing bearing in mind what the reader wants. And all legal writing advice should be based on what does the reader want from your writing. And using the first tip, I think that was explained or given here, that if you're writing to a judge, you're looking to persuade the judge. You're not looking to persuade yourself, okay? You're looking to persuade the judge. How can I persuade the judge? What devices can I use? What language can I use? How shall I structure this thing? If I'm writing to a client to advise a client, then I've got to think, how will the client understand my writing? How should I structure everything? What's important from the client's point of view? If you're writing to opposing counsel and you want to persuade them into a course of action, then you've got to think, how can I structure my arguments to persuade them to try and see things from my side? Once again, you're thinking about how the reader interprets the document. It's not the case of, let me show off my skills. You've got to tame your ego. It's all about the reader. Okay, that's the final comment that I would leave you with today. Okay, see you soon in another video.